Senate will come to order. Roll call, please.
Roll call, Wednesday, October 27th. Anderson.
Here.
Baldwin.
Here.
Beitman. Boner.
Here.
Bouchard.
Here.
Case.
Present.
Cooper.
Here.
Driscoll.
Here.
Ellis. French.
Here.
Furphy.
Here.
Guru. Excused, Hicks.
Here.
Hutchings.
Here.
James.
Here.
Kinsky.
Here.
Cole.
Present.
Cost.
Here.
Landon. McCune.
Here.
Nethercott. Excused, Pappas. Excused. Perkins.
Here.
Rothfuss.
Here.
Salazar.
Here.
Schuler. Scott.
Here.
Steinmetz. Wasserberger.
Here.
President Dockstader.
Here.
27 present, 3 excused.
Chair by Senator Salazar.
Be effectively restored, and truth and justice and piety prevail and flourish amongst the people. Preserve the health of their bodies and vigors of their minds. Shower down on them and the many they here represent such temporal blessings that thou seest expedient for them in this world, and crown their justice with everlasting glory in the world to come. All this we ask in the name and through the merits of Jesus Christ, thy Son, and our Savior. Amen.
Cole, will you lead us in the pledge? Thank you, Senator Salazar. Senator Cole, appreciate your help getting the day started. Messages from the House. We'll wait just a moment.
October 26, 2021, corrected message number 3. Mr. President, this is to inform you that that Representative J.D. Williams has been appointed to the committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, suspending with further reading. Sincerely, Wendy Harding, House Chief Clerk.
Thank you. Reports from standing committees. Let's proceed then. Consideration of bills on general file. Well, we do have. All right. Let's go with the journal report.
Mr. President, your Journal Committee reports that the Journal of October 26, 2021 has been read and recommends that it be approved. Signed, Senator Cole.
Reports on standing committees. Senator Scott.
Mr. President, with regard to the journal, I believe it includes the official ballot on the calling of this special session. And I understand I'm recorded as not having responded on time to that. I would like it noted in the journal that I was unable to do so because I did not receive the official ballot they asked to send back until 24 hours after the deadline. I think the storm and an error in delivery in combination were the cause of the problem, Mr. President.
Okay, for the record, thank you. Let's go to reports from standing committees.
October 26, 2021. Mr. President, your committee number 10, Labor, Health and Social Services, to whom was referred Senate File 1009, COVID-19 Response 2, respectfully reports same back to the Senate with a recommendation that it do pass amended. Voting aye, Senators Baldwin, Bouchard, Furphy, Hutchings, and McCune. Signed, Baldwin, Chairman. Mr. President, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom was referred Senate File 1019, Wyoming Gaming Commission, Scrivener Error Correction, respectfully report same back to the Senate with a recommendation that it do pass. Voting aye, Senators Boner, Case, Driscoll, Nethercott, and Scott. Signed, Senator Driscoll, Chairman.
Thank you. We're that order of business. Mr. Majority Floor Leader. Consideration of bills on general file. Go ahead.
Mr. President, I move the Senate resolve itself into committee of the whole.
Heard the motion. All those in favor say aye. Aye. Those opposed, nay. Senator Wasserberger, you're in charge of the Senate.
Committee of the whole will please come to order. The first bill for our consideration is Senate File 1019. Would the reading clerk please read the Senate file?
Senate File 1019, Wyoming Gaming Commission, Scrivener Error Correction, an act relating to the Wyoming Gaming Commission, sponsored by Senator Ellis. It was referred to committee number 7, who returned a recommendation that the bill do pass. Voting ayes were Senators Boner, Case, Driscoll, Nethercott, and Scott.
You've heard the reading of the bill. What is your pleasure? Senator Ellis. Senator Driscoll.
Mike, I'll go ahead and just do a quick explanation. I'm not going to spend a lot of time. We talked about it yesterday. This is what's called a Scrivener's error. So we actually had a section of a bill got struck out last year that had some pretty grave consequences as far as gaming regulation and how it works in the state of Wyoming. And this bill does absolutely nothing other than to correct an error in it. With that, I'd stand for questions and ask for your approval.
Committee of the whole, what is your pleasure? Senator Bouchard.
Thank you, Mr. Chairman. You know, I heard people say yesterday that we came down here and even that we shouldn't be here. We could have waited till session. Now we're down here doing bills that we should be doing during the session. Did we not see all the people here yesterday that came down here because they're worried about what's going to happen to their jobs? We're just going to go around business as usual. I'm going to vote no on this just for that reason.
Committee of the whole, what is your pleasure? Senator Case?
Well, Mr. Chairman, we do have to be a responsible legislative body. This bill is brought by a colleague who has worked in this area for a long time, and we made a mistake last year. We all need to owe up to that mistake when we left the session. The mistake potentially had serious consequences. Whether you're for gaming or not for gaming in Wyoming, that's not really the issue here. We had an error in a bill that potentially and probably left an entire area of about gambling unregulated in Wyoming, potentially. We had created a commission, a gambling commission. It repealed all that language, the mistake did. So we ended up back with the parimutuel commission, which is not capable of handling the new types of games and things that we have approved on a trial basis. And actually this bill creates kind of a wedge. And the way I understand it is that the industry is being really nice to Wyoming. They could have driven trucks through that wedge and we'd have wide open gambling in Wyoming, which I don't think any of us want. Wide open, unregulated gambling. This is a good bill. When the legislature meets, it can fix something, we should do that. It tags onto the special session, but I guarantee you, Mr. Chairman, it did not have any impact on any of the other bills. We will find as we proceed that there will be lots of time when you'll be sitting in this chamber with nothing to do. Because committees, you can't always be in committee. The bill you're looking for is somewhere else. So it's going to be kind of like the end of the session, Mr. Chairman, when there's a lot of seat time. Don't the people of Wyoming deserve that we fill some of that seat time with something that's truly useful, which is to fix and own up to a problem that we made? Urge your aye vote, Mr. Chairman. Thank you.
Senator Driscoll, and then
It's come to my attention. I may have moved this incorrectly, so I'm going to go ahead and make the motion again, just to make sure for the record I've done it correctly. Mr. Chairman, I move that when the committee of the whole rises to report, it does so with a due pass recommendation on Senate File 1019. Thank you.
Thank you, Senator Driscoll. Senator Hutchings?
A violation of a couple of the rules. It's on. Thank you. Violation of a couple of the rules and Masons was brought to my attention yesterday, and I feel compelled to just let people know. Again, you can vote how you wish, but the call of our special session was specifically to deal with COVID and the vaccinations. Special rules that we tried to adopt failed. So now we are under our normal rules of the 66, and those rules are governed by Mason's rules or laws. Mason's Chapter 72 and Section 780 state, while a legislature cannot go beyond the business specified in a call for an extra session, yet within such limits, it can act freely in whole or in part or not at all. And that's number 4 within that chapter. And then number 9 states that when the Constitution prohibits passage of legislation not included in the governor's call, or in this case, the legislature's call, according to Article 2, Section 7 of our Wyoming Constitution, legislation passed at a special session not within the call is not valid and is not validated by the signature of the governor. I just wanted to let everybody know that we may be in violation. So you can choose how you want to vote. Thank you, Mr. Chairman.
Senator Ellis?
Thank you, Mr. Chairman. I haven't had a chance to review what my colleague just mentioned, so I'm happy to do that on a future reading, but a few things to describe. Again, just kind of the history of what happened with this bill. Prior to 2020, skill-based amusement games or skill games were operating in Wyoming without regulation. In 2020, Wyoming passed House Bill 171 to provide a regulatory framework. And if you look in your inbox online, you're going to see a copy of that bill. If you look at that, it's referred to as, I think, Session Law 114 maybe. It's also House Enrolled Act 95. But section 1 of that bill required some regulation of these games. And so it said that those individuals that had them in operation had to get a license. It provided some parameters on how much money could be put in the machine, how much could be paid out, limiting the number of machines per establishment, et cetera, et cetera. Section 1 was all done through session law, and it also contained a sunset so that we as a legislature could have a 1-year look at how many machines were operating in the state and decide whether or not we wanted to continue to have those machines in operation or perhaps pull the plug on them entirely. Section 2 of the bill started amending existing codified law. One of those amends the definition of peace officer. We wanted this newly created gaming commission that was formerly the parimutuel commission to be able to hire peace officers. And we clarified in amending those statutes that those peace officers for their service and their benefits would be considered Wyoming peace officers for things like their retirement benefits. It also made a number of changes. It added 2 different individuals to the newly created gaming commission. One was a law enforcement rep and one was a member of one of the recognized tribes in our state, recognizing that those individuals have a lot of gaming experience that might be beneficial for this newly created commission. And so it did a number of things. And if you look through the definition, you'll see some other amendments made to penalty provisions and whatnot. So after this bill passed, House Bill 171, we had that year. And in 2020, the Travel, Recreation, Wildlife, and Cultural Resources Committee heard testimony from the operators who wanted to make these games permanent. And instead of having a 1-year sunset, allow them to continue to operate indefinitely in the state. So that bill, House Bill 56, sought to codify Section 1 of House Bill 171 from the prior year. So to do that, we would normally repeal just Section 1. Unfortunately, the repealer that was contained in Senate File 56 repealed the entire prior changes that were made in 171. So as a result, there are some very insignificant things, in my view, that could be dealt with at a later point in time. For example, it created the Wyoming Gaming Commission. Because we deleted that section, the commission is now re-referring to itself as a parimutuel commission. Not the big deal, not the end of the world. The 2 additional commission members that were added no longer have voting rights on the commission. Again, maybe we could argue that that's not urgent. But what is significant is the law enforcement. We are messing, and because of our error and a complete mistake, these individuals their eligibility for their retirement and participation in Wyoming retirement is called into question, as is their ability to do their job to make sure that they're enforcing the statutes that we provided. So why did I bring this? Members, I'm not in leadership. I wasn't in any conversations with leadership when it came to discussions about whether or not to bring this special session. I have concerns when we call these special sessions on who actually gets to bring the bills. Is it just 1 or 2 people that we actually allow to participate in that process? But I think we saw a number of people filed, 40 bills that we all asked everyone to consider. And we took significant votes on those yesterday. So that's why I brought the bill. I think this is urgent. I also think that it isn't controversial. It's owning up to a mistake. And colleagues, trust me when I can tell you, brings me no delight in showing this to you. It's a mistake that I missed, our legislative staff missed, the governor's office missed, the attorney general's office missed. There's no fun in admitting that we made a mistake, but we need to own it. We need to fix it and make it right. So we can either do it today and this week, making use of our time, as a prior colleague mentioned. There will be a lot of downtime where we're just going to be sitting around here. And that's fine. That's what we do every year when it comes toward the end of session. Our days get lighter and we fill that time. To me, this is an efficient way to use that time and those taxpayer dollars to hear a bill that doesn't make any substantive policy changes, but corrects a necessary error that we made. And I'll carry the blame for that. I made that mistake. I didn't catch it. And I'm sorry, colleagues. But I'm bringing it to you humbly and asking you to pass this bill unamended because it isn't controversial. It corrects a very important mistake.
Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, first of all, on and for the bill, I just agree that we're correcting an error. It's good practice to correct errors when you can, as expeditiously as you can. And this is nothing beyond that. I don't think there's any real policy implications. other than fixing something that we screwed up through a technical error. Regarding the constitutionality and Masons, this is very constitutional. It would have been out of the rules had we passed the alternative rules, and therefore it would not have been in order. From a constitutional standpoint, limits on the topics for the special session come when the governor calls a special session. And at that point, those provisions in Masons apply, because that's what 780 is referring to, is a call by the governor. When there are provisions in the Constitution that require adherence to a governor's call for a special topic, special session, those are the rules that are recommended by Masons to bind. And again, our internal rules could override those. When you look to our Constitution, there is a clear and intentional lack of discussion about any particular topics when the legislature calls itself in. Now, it's typically calling itself in for a purpose, but it is not bound by a particular purpose in the call, even if there is a statement of that purpose in the call. So we all know that there was a letter, that letter had a purpose in it, but we are not bound as a legislature by that purpose, by the Constitution, by the rules, by Masons, or by anything else. So this legislation is in order. Thank you, Mr. Chairman.
Senator Scott.
Mr. Chairman, on and for the legislation. I think my colleague just dealt with the constitutional question. I won't go into that. I think it was correct. Mr. Chairman, I voted for this on introduction yesterday and committee yesterday because my understanding is that the magnitude of the possible trouble that will be caused if this bill and this error is not corrected is such that we might have had to have a special session anyhow. Somebody had started exploiting the accident that happened. So I think it's appropriate. In general, I'm not in favor of going into any other topics at this special session, but this one might have merited a special session on its own. So this is, frankly, Mr. Chairman, we ought to take advantage of the opportunity. And I would say one thing further, Mr. Chairman, on fault. You know, we're all human in this place. I don't know how many sets of eyes looked at that particular provision and didn't see the consequences. These things happen, Mr. Chairman. The sensible thing is just fix them.
Question being called. Are you ready for the question? All those in favor of Senator Driscoll's motion that when the committee of the whole rises to report, do so with favorable recommendation of Senate File 1019, say aye. Aye. Opposed, no. Senate File 1019 has passed committee of the whole. The next bill for our consideration. That is it. One more. Senator Driscoll.
We don't have it. It's not ready though. Mr. Chairman, I request committee of the whole stand at ease, sound of the gavel.
We will stand at ease until the sound of the gavel. Senator Driscoll, does that need to be to beg leave and rise again? Mr. President, would you approach the chair, please?
Members of the Senate, stand at ease until the sound of the gavel. Senate will resume. Committee reports.
October 27th, 2021. Mr. President, your committee number 2 appropriations, to whom was referred Senate File 1003, COVID-19 Discriminatory Practices Prohibition, respectfully reports the same back to the Senate with a recommendation that it do pass with the following amendment. Voting aye, Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Signed, Drew Perkins, Chairman.
Consideration bills on general file. Mr. Majority Floor Leader.
Mr. Chairman, move the Senate resolve itself into committee of the whole.
For the motion, all those in favor say aye. Aye. Those opposed, nay.
Committee of the whole will please come to order. Committee of the whole will please come to order. The next bill for our consideration is Senate File 1003. Would the reading clerk please read the bill?
Senate File 1003, COVID-19 Discriminatory Practices Prohibition, an act relating to miscellaneous offenses, sponsored by Senator Steinmetz. It was referred to committee number 2, appropriation, who reported back a recommendation to the Senate that it do pass amended. Voting aye, Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz.
You have heard the reading of the bill. What is your pleasure? Senator Perkins, there is a standing committee amendment. Senator Perkins.
Thank you, Mr. Chairman. I move that when the committee of the whole rise and report to do so with a do pass recommendation on Senate File 1003 or 1003. And at this time, I'd also like to move standing committee amendment number 1 to Senate File 1003.
Would the reading clerk please read in the amendment?
Senate File 1003, SS 001, page 2 after line 19.
Senator Perkins, would you move the amendment, please?
Sure. Now that it has been, and I will move it. Thank you. So I'll remove the amendment. So I move standing committee amendment number 1 to Senate File 1003 for an explanation of the bill and the amendment. I will ask that you call upon the good Senator Steinmetz.
Senator Steinmetz.
Thank you, Mr. Chairman, and thank you, body, for taking up this good bill today. As you know, on May 7th, 2021, our chief executive issued a statewide directive prohibiting vaccine passports, and this is further work on that issue. We do have some amendments, and so as I go through the explanation of the bill, I will also take you through the amendment. So if you'd like to pencil it in, then that might help you as well. So basically, we're going to start out in the insurance code because this deals with prohibiting discrimination based on COVID-19 vaccination status. And it also deals with insurance. So if you go to page 2, you'll see that that is Title 26, the insurance code, and the mandated coverage. Those definitions that you see on that page will correlate to page 5 of the bill. And your first amendment that you will have is on page 2, line 19. We have defined insurer, and an insurer means an insurance company or health service corporation authorized in this state to issue policies or subscriber contracts that reimburse for expense of healthcare services. So we wanted to make sure that that was taken care of. We want to make sure that an insurance provider shall not use a COVID-19 vaccination status of a person basis to reject, deny, limit, cancel, refuse to renew. And then there's your next change is we deleted increased premiums for, because we felt that we were venturing a little too far there. Or so it will continue to read, limit the amount, extent or kind of coverage available or otherwise adversely affect eligibility or coverage from the group or individual health policy, contract, or plan for health insurance. And so basically, we're saying you just can't cancel or limit or refuse insurance on vaccination status, whether it be vaccinated or non-vaccinated. That's all we're doing, prohibiting that. Then also the insurer providing group or individual policy for the plan shall not use the COVID-19 vaccination status as a qualification or requirement for contracting with a person's healthcare provider or for a basis of terminating the contract with the person's healthcare provider. And then the next change that we do is on the bottom of page 3. We're taking out the penalties. So line 19 through 22, that is your next deletion. We felt that that was too punitive, and so, we're taking out the incentives. So we just felt they should be able to incentivize vaccination if they would like to do that. So that's what we're doing there. On over to page 4, we're just saying they can't provide penalties. And health insurance, the vaccination status shall not be used in a factor in rating the group or individual policy. So that has nothing to do with claims. That is just your vaccination status. They'll still be able to rate for claims just like they normally would. So then, and there was a couple of deletions there that I mentioned just going through the bill, and it's contained in your amendment. So next we go on to your definitions page. On page 5, we just define COVID vaccination, vaccination status, and public accommodation, what that is. Then we go on to no person shall on page 6. Refuse, and this is kind of the meat of the bill, refuse to withhold or from or deny to a person any services, goods, facilities, advantages, privileges that are public in nature or that invite the patronage of the public in any licensing, employment opportunities, educational opportunities, or healthcare based on the person's COVID-19 vaccination status, or whether a person has COVID-19 immunity passport. The next change we make is we delete on page 6, lines 10 through 17. We didn't want to have a bump in with free speech there. So we're taking away the ability to ask or inquire into a person's COVID vaccination. We said they can't do that. We're not doing that any longer. We're saying they can have that free speech. So, and then on C, we're just saying no public accommodation shall exclude, limit, segregate, or refuse to serve or otherwise discriminate against a person based on the COVID-19 vaccination status or whether they have an immunity passport. And then we put in fines and penalties on page 7. And then we go into all of the exemptions basically. And there was a small correction on page 7. Just some adding 26(1), 102. So basically the rest are going into the Code of Civil Procedures and the general provisions of civil actions with, that was the business liability that we passed the last time. So we're just amending all the conforming amendments that go into making this work in our statutes. That's basically the rest of it. One of the things we did discuss was on page 8, whether a private school is a public accommodation facility, and it is, and so that is included, just so that you're aware of that. Then our next change is on page 10 after line 7, and we're just inserting some more definitions. And then we made a deletion on page 10, line 23. So that's basically the bill, and what the bill seeks to do is just to go ahead and put us all on an equal playing field. When you're talking about vaccination status, it's whether you have or have not been vaccinated. No one can discriminate against you based on that. So that's the bill. And thank you, Mr. Chairman. I would stand for any questions.
Senator Steinmetz, would you prefer us do the amendment first, or would?
Mr. Chairman, if we could dispose of with the amendment, I think it makes the bill a lot better. So I would call for the question on the amendment or any or answer any questions on it.
Thank you, Senator. We will, we are on the amendment. Senator Brightman.
Thank you, Mr. Chairman. My question on the amendment is regarding on page 6, lines 10 through 17, deleting that paragraph 2. Little more explanation as to why you decided to delete that. To me, it seems like a pretty important piece of this legislation to inquire about a person's status in order for the person to access any services, goods, facilities, advantages, and privileges that are public in nature. It seems to be consistent with other civil rights statutes. Why would you take this out? Thank you, Mr. Chairman.
Further discussion on the amendment? Are you ready for the Senator Scott?
Mr. Chairman, my inquiry is to the committee as to whether they've heard from the insurance department on the insurance provision here. I'm a little out of date in this area, may have changed, but there was a provision in Obamacare where if you mandated a coverage, the state could be responsible for all the costs of doing that. I don't know whether this qualifies for that at all. In some ways, it's saying you can't discriminate based on this particular pre-existing condition, whether you're vaccinated or not, what your status is. So maybe it's all right. But the penalty is fairly severe. And we've gotten caught once with it. If you mandate a new coverage, and it's a technical area, I don't pretend to know what the answer is to this question. So my question to the committee is, did you hear anything from the insurance department on that particular issue, whether we're any risk of incurring any liability to pass this?
Senator Perkins, we are on the amendment.
Thank you, Mr. Chairman. On the amendment and in response to Senator Scott's question, the answer is no, we did not. We had one attendee last night that was there and did participate in and did make public comment. It was representative from an insurer, a health insurer in the state of Wyoming. And her, she was obviously there following the insurance provisions, and her comments were essentially along the lines that her biggest concern was some language that we did strike were about in premiums, because there's just so many things, Mr. Chairman, we don't know about COVID, whether the disease or the vaccines or the lack of vaccines. And it'll be 10 years before we start, I think, before we start to fully understand the effects of the longer term effects of the pandemic and our responses to it. And so, as the amendment did, it struck the language with respect to rate premiums or to with respect to claims, and you still have to spread those costs across the pool regardless of where they are. And so, other than that, the comment was generally that they as insurers didn't do most of the things that we're prohibiting anyway. And their biggest concern was be able to adequately reflect costs across the pool. And so we've adjusted that and thought that was covered under the concept that you can affect, and it's recognized in the industry, according to our understanding, that when you raise the premiums past a certain rate, it is essentially a constructive termination of the policy or cancellation of the policy. And so we've already got a prohibition against cancellation based upon whether you're vaccinated or unvaccinated. With respect to the insurance department, very good question. I think as this passed out, there's still a lot of trepidation from the committee that doesn't have a tremendous amount of experience in this area. We do have some of us did sleep at a Holiday Inn, and some of us, I'm sorry, not supposed to use prices today, but anyway, we did the best that we could with what we had. We moved this forward because we thought it had several items in it in our response to COVID that were right at the heart of why we're here at this special session. We thought we ought to explore those and figure out how to move this forward and bring it to the collective body to see if we can move it in a direction that it should become, it should be passed and become the law of the state of Wyoming. So that's another good thing about why we slowed the session down, so that this is really important. This is going to affect a lot of people in a lot of situations. It clearly has broad, significant potential for unintended consequences going forward. As my good tall senator from, my co-senator from Natrona County had just indicated. On its face, I think that we're not mandating coverage, which is a very significant thing. We're simply saying we're not saying you can't take it into claims consideration. We're just saying you can't simply laser or pick that particular item and rate it up and down based upon solely that item in that group. And so we're trying to, we've had some comment, some information came to the committee that this is a concern about insurance agents going forward, that based upon whether you've had right now, it might be if you haven't had vaccinations, but who knows in the future, maybe because you have had a vaccination, that all of a sudden that pre-existing condition results in pricing. And the other thing we're trying to do is prohibit an insurance company from pricing someone out because they have or haven't had a vaccine. So you have a small insurer, a small group has a group policy, have a small employer, maybe, might be a large employer, but obviously a small employer, that because that they have not been vaccinated or because they did get vaccinated, that the insurance company simply says, that's not a risk we're going to take anymore, and price them out of the market based upon that, based upon the fact they have had vaccines. At the same time, we are recognizing that one or the other may end up with significant costs, the healthcare costs in the future, and you have to allow that then to be spread across the group and let that affect what happens on. So that's in effort to that, I think most of the issues have been pointed out. Just a couple of highlights that I'd like to bring to your attention is, again, at the top of page 3, we struck that language about increase the premiums for, or limit or extend the amount of coverage. So it's not mandating coverage, but it is prohibiting you from rejecting, denying, limiting, canceling, and refusing to renew or limit the amount or extent of coverage based solely upon that vaccine status, whether you're vaccinated or unvaccinated. And so, but that's a really good, we know that's an answer we need to have, and that's the reason why we slowed this down, so we can maybe find out answers to that. With respect to the question about why we canceled or why we struck on page 6, lines 10 through 17, asking a person to inquire into a person's COVID-19 vaccination status. There may be very significant reasons to do that. You may have people who work in establishments. You may be, keep in mind, it could be a assisted living center or a skilled nursing facility where you have certainly susceptible people, and it may be very important to ask certain questions about not just this, but other healthcare issues about whether you come when people come in. In some cases, that may be prudent, extremely prudent. In other cases, it may not. In addition to that, I think it seems to me that there's kind of a First Amendment issue with simply not being able to ask somebody something. Doesn't mean you have to respond. Doesn't necessarily mean you have to do that, or to respond in a positive way. And if you refuse to respond, then you still have the ability that you can't, that service can't be withheld or refused to you simply because you didn't answer or based on that basis. So that we're trying to make this broad enough to give employers discretion to create the workplace that they have, but also still try and bring some purpose to the fact that whether or not you're vaccinated, that in essence, we'll talk about this some more, but when we talk about public accommodations, what we're doing here is effectively creating a protected class for whether you're based on vaccinated status. And the point is that you can't, the effect of this provision at this part of the bill and this one in particular is that you're raising vaccination status to the matter of a protected class. that's essentially equivalent with race, religion, sex, or a creed, and those types of protected classes. And so it's an important discussion to have, and I think it's important for us to realize what it is that we're doing and work this bill as it goes forward and see if we can at some point get it to where it really does the good that's intended by bringing the bill. So those are my comments so far. I think I've tried to answer the two questions we've had so far. Thank you.
Senator Kinski.
Thank you, Mr. Chairman. And to further emphasize in response to the question from my colleague from the north, on page 7, you'll see that we make this a crime. And on page 6, Romanet 2 says it's a crime to ask a person or to inquire. That clearly is a violation of the First Amendment, to make it criminal to speak. And so, as my colleague from the committee said, you don't have to answer, but you can't write a criminal penalty out to somebody for exercising their free speech right. Thank you.
Senator Brightman.
Thank you, Mr. Chairman. There are still some things you can't ask your employees or a potential employee in a job interview. That runs you into a big problem if you do. And so again, my question is, how do you ascertain somebody's COVID vaccination status if you don't ask them? And if now we, take that portion out of this bill, it, in my mind, really guts the bill and the intent of the bill. I think it's important to keep this in there. The free speech argument doesn't really hold a lot of water when it comes to violating somebody's civil rights. So, and asking them for the purpose of denying them services or denying them employment, to me is a no-go. So I would like to divide the amendment. Division 1 being this portion here it would be lines 18 through 24 being Division 1, and the remainder of the lines 1 through 17 and 25 through 41 being Division 2. Thank you, Mr. Chairman.
Senator Brightman, would you go over that division again, please?
Yes, sir. It's Division 1, lines 18 of the amendment through line 24 of the amendment. Division 2 being lines 1 through 17 and lines 25 through 41.
Okay, division number 1 is lines 18 down to 24. And so that is page 5 through page 6. And so division 2 is the rest of the amendment, Senator? Okay, does everybody have that? It is divisible. We are on division number 1 to amendment number 1 to Senate File 1003. Senator Perkins.
Thank you, Mr. Chairman. I think that I think that what you have, and I understand the concerns. The problem is the way the bill is written and where this is, that it's not limited to employment. It's limited to inquire into a person's vaccination status or ask to inquire whether a person has immunity passport in order for that person to access any goods, services, facilities, advantages, privileges that are public in nature. So we talk about what a public accommodation is. It's not just employment. If this only dealt with employment, I think that's fair enough. But this isn't everything else. Public and private accommodations are restaurants, stores, nursing homes, private schools, public schools. You go, so you think about your a school or an aftercare program. So if you've got private schools, you've got a think of a religious institution running a school or a daycare. Think of those types of things, and they're included in public accommodations. So it's not just employment. And so, in fact, I did today. In fact, if I just asked, we were one of my colleagues on the appropriations committee said I need to be excused because I need to go get a shot. And I asked him, I just after said, oh, are you going to go get a booster? And then all of a sudden I realized that under this bill, I've just committed, I may have just committed that because he's in this and potentially that's about whether he gets to participate on my committee or not. And so you come back and you're creating the same crime that you're creating a crime, the same crime that you do if you discriminate or refuse service based on a person's religion or their sex or their origin, their nationality, their race. And you're saying, you can't. So that's why that's removed. I understand and appreciate and don't necessarily disagree that it's an appropriate employment question unless you're under some kind of mandate. But it extends much, much further than employment. This is if the point is to get employment, we need to have a rifle shot instead of a blunderbuss or a scatter gun on this one. Thank you, Mr. Chairman.
We're on division number 1 to amendment number 1 on Senate File 1003. Is there any further debate? Are you ready for the question? Question being called. All those in favor of Senator Beitman's division number 1 to amendment number 1 of Senate File 1003, please say aye. Did I state that wrong? Okay. Thank you. So let's go back. All those in favor of Senator Perkins' motion to adopt Standing Committee Amendment number 1, Division number 1 to Senate File 1003, please say aye.
Aye.
Opposed, no? Motion failed. We are division being called. All those in favor of Senator Perkins' motion division voting aye, please rise. Opposed, please rise. The division has failed. The division has been adopted. Okay, we are back on the amendment. Any further debate? Question? Division number 2. Question on division number 2. All those in favor of Senator Perkins' motion that Standing Committee Amendment number 1, division number 2 to Senate File 1003, please say aye.
Aye.
Opposed, no? Motion, the amendment has passed. We are back on the bill. Senator Case.
Thank you very much, Mr. Chairman. I'd like to discuss kind of the issue of the public accommodation, really what that means. And I think in some of the discussion of the Standing Committee Amendment, we did touch on that. But a lot of people think that public accommodation is just hotels or lodging. And it's much, much more than that. I happen to be in the hotel business. But this is the Wikipedia version. Oh, sorry to use that proper name. A public accommodation is a private entity that owns, operates, leases to a place of public accommodation. Places of public accommodation include a wide variety of entities, such as restaurants, hotels, theaters, doctors' offices, pharmacies, retail stores, museums, libraries, parks, private schools, and daycare centers. That's a big bunch of entities, Mr. Chairman. And so I'm a mother, I have a child. I'm sending to her daycare center. It's private business, private money. I want the best for my child. I want to choose a daycare center where the people are all vaccinated or have some kind of certificate, whatever that might be. Why isn't that my right? Why are you interfering with that right? What if, I sometimes like the nightlife in Cheyenne, and there might be establishments that have a requirement that all the patrons have particular healthcare status. There might be other establishments that do the opposite. It might be kind of fun, but why isn't the owners of those rights to do that? This is not an issue of race, creed, political party. This is, whether you can get somebody else sick or not. And we can argue about the science. But why are we going into this space? This public accommodation is way, way, way too broad. And I'd urge you to oppose this bill. Thank you.
Further debate, Senator Guru. Senator, you are on according to my computer.
I don't see it.
You are
There
red
we go.
over there. You go.
There we go.
Slam it down.
Thank you, Mr. Chairman. On and against the bill. We worked this bill in committee, and I appreciate your passage of the amendment. And I think it made it a better bill, which is what we always try to do. Unfortunately, and once again, I did vote to bring it to the floor because that's why we're here, is to have this discussion. That's why this special session was called, to the best of my understanding. And so we need to have this discussion. My good friend from the Wind River country is right. This bill has far-reaching implications. This bill is a huge bill. Spans the width and breadth of business across this state. And that is my fundamental concern about it. I think, and you'll be hearing this a lot from me this week probably, but I think this bill looks at one overreach that could possibly happen and then take another overreach that I think is far more draconian to try to fix it. As a business person, this bill is bad business. This bill is anti-business. And I have to say that I'm a little surprised that a bunch of folks who I hear all the time during campaign season and say that they're pro-business put out a bill that in my view is anti-business. And that I find myself on the other side of that. It might surprise some. But as a business person, I just have a deep philosophical concern here that I'm put now, if this bill is passed, in a Hobson's choice of following one guideline and getting in trouble with one government or doing another and getting in far worse. Criminalizing me either way. That may not come as a surprise to some of you about that criminal part with me, but it's not something I look for every day. So I urge you, ladies and gentlemen, good friends in the Senate, to think hard about this bill, the implications of it. I am appreciative of the fact that we're going to have an opportunity by not voting for the rules that we had in front of us yesterday, that we're going to have this discussion. This is a discussion we should have. On and against. Thank you, Mr. Chairman.
Senator Hicks and then Senator Landon.
Chairman, I listened to my colleagues and I think they highlight some of the opportunities that we have here. And because we do have an extended session, and typically we have 3 opportunities to amend the bill. And so as part of the process that we often recognize here is bills don't always come to the floor in a perfect fashion. That's why we have 3 readings, folks, for an opportunity to address those concerns from my colleagues from Fremont and Teton County. I think the last debate on the division actually articulates and shows that and demonstrates that pretty well. I concurred with the chairman of the appropriations, but I also concurred with my friend from Sheridan on his concerns about employment discrimination. We can fix that pretty easily with the second reading amendment to accomplish both objectives and both concerns. So I would encourage you that we should continue to debate the merits of this bill. And then each and every one of us will have an opportunity on the third reading to make a final disposition of whether we agree with it or not. But right now, let's honor the process. We're here, folks. Let's do the debates. Let's work the bills. Give them an opportunity to correct deficiencies or concerns expressed by the body here. I would encourage you to vote for this bill and let's continue the dialogue.
Senator Landon, and then next Senator Boner.
Thank you, Mr. Chairman. I would like to take you to page 7. At the top of the page, paragraph D and paragraph E. And I'm looking over in the direction of my attorney. And I'd just like a little more conversation. It would help me to get arms around what these two paragraphs do if we could just have a little more conversation about it. So paragraph D is all about if you violate subsection B, and that includes all those things aforementioned, that this business could be fined $750, and somebody from that business could be thrown in jail for 6 months. I'm wondering how that would take place. I'm trying to envision, I suppose it would take some kind of a complaint, and then the police department or the sheriff or somebody would show up and arrest somebody in that business. But I'd like to find out if I perceive that correctly. And then in paragraph E, we talk about a civil course of action. My question there is, don't we all have the opportunity for a civil course of action now? I mean, does it take us doing this to give someone an avenue for civil damages? Thank you, Mr. Chairman.
Senator Boner.
Thank you, Mr. Chairman. I appreciate the opportunity to weigh in here. Just want to first of all state, that I share a lot of the concerns that my colleagues have voiced about making sure that we are respectful of property rights, of people's ability to run their businesses. And just to briefly state that I do appreciate a lot of the work that's been put into other pieces of legislation that attempt to strike a balance, and just like to point out that this bill needs a lot of work if we're going to get across the finish line. I don't see a whole lot of attempts at balancing everybody's rights in this piece of legislation as it stands. But one particular question I have for the sponsors of the bill, it deals with a concern that I heard that was raised based off of some of the previous testimony about requiring potentially religious schools, private schools with religious affiliation to do something that may be against their beliefs. So I'm just a little bit curious about how this would interact with the right to free expression of religion, of course, guaranteed under our U.S. Constitution, and how that interacts. Clearly, I think it seems like it affects private schools run by a religious organization, but just need a little bit more information as to whether that would actually extend to places of worship themselves. Where do we draw that line?
Senator Perkins.
Thank you, Mr. Chairman, and this is great discussion. This is exactly, so going back to the bill as a whole, let me just explain. There's really two major portions of this bill. It could have easily been two bills. I'm not suggesting that it's not within the topic. I believe it is. It's clear within the topic. But this bill really does two things. So the first part of the first section is obviously it tries to look at and remedy some issues with respect to insurance and having people specifically identified and lasered out, and having a company effectively price them out or otherwise just deal with them or cancel them because they've got, so that's the first part it does. We've gone through that. The second point and part of this is to deal and to make COVID vaccination status, which means you're vaccinated or unvaccinated, a protected class. And so we already have a public accommodation statutes in 69101. And basically you go out and you go to the long list of public accommodations that which we talked about already and were amplified by the good senator from the Wind River country. And so that's, I mean, it's far reaching. And so the public accommodation statute that we have in 69101 simply says that all these things that you're doing, including, private school or public daycare, you can't discriminate against someone on the basis of race, religion, national origin, sex, or nationality. And so we've heard of those things as protected class. When you get to employment, they also enjoy certain benefits from being a protected class. And you can't, and also the ADA, the American Disabilities Act, and a few other acts come back in and cover and say, in some instances, we're also going to include people with disabilities as a protected class to the extent work, if there can be reasonable accommodation made to deal with them. And so those are all various forms of protected classes. And so the other part of this bill, absent the insurance, is that to create and create a new public accommodation statute that actually amplifies the existing statute of 69101, which is in crimes and offenses. And so if you are a purveyor or an owner or a lessee or a lessor of a public accommodation, and you deny service to someone, and which includes employment, and that's one of the issues we have to kind of sort out here on the basis of race, religion, national origins, creed, sex, those types of things, then that is a crime. It's a misdemeanor punishable by, say, up to 6 months in prison and $750. And so if someone was aggrieved under the as a protected class person under this statute or the existing statute, then you would swear out a complaint and the sheriff would go down there. You might be, most likely what would happen is you'd probably be cited, but you could be arrested. It depends on the situation. We're all very aware of, and we've discussed in this body previously, certain cases that were gone with cakes and other things and people who were public accommodations. And we've discussed this before in expanding protected classes for public accommodations before. And so talking with one of the other sponsors of the bill, I mean, originally this started as an amplification or change in sections in Title VI, which is crimes and offenses. Started there, but another co-sponsor in the bill wanted it differently. He wanted to create this public accommodation statute in the health statutes because he didn't want it to get mixed in with the crime and offense statutes. But ultimately, it's the exact same crime. It's the exact same crime that is in 69101 at this point. And what we're doing, the language is very same. It's amplified in some degrees. It obviously has significant definitions to understand what COVID-19 status is. But ultimately, that's the effect of this part of the bill, is it creates and makes this public accommodations crime extend to COVID-19 vaccination status. With respect to the lawsuit, there is no similar provision in the existing criminal statute. That's because you already have a remedy. It's a civil rights remedy. It's called a 1983 action, where you sue someone because under color of state law, you've been denied your rights at this public accommodation. And that's where you see the lawsuits we've had with bakers and wedding dressmakers and things like that. I think most of us are aware of those. And so whether you have it in the health statutes, or whether you put it in 69101, or you make a new article in the crimes and offenses, it is the same crime. We're raising this to at least a semi-protected class, if not a fully protected class, on vaccination status. And some of you may think that's a good idea, but a good idea, and some of you may think it's not a good idea, but that's the effect of this portion of the bill, whether it's in, whether we put it in the crimes and offenses statute, or whether it stays in 35-140, or where we've got it proposed as a new section. So that's my attempt to answer the question of the good senator from Orange Junction and my good colleague from Natrona County. Thank you, Mr. Chairman.
We are back on the bill. Senator Cost.
Thank you, Mr. Chairman. I'm going to approach it from another angle, and if I'm all wet, say so, because I'm not sure, but I'm stepping out on a limb here. In looking at this and looking at insurance in the state of Wyoming, if insurance companies can't ask what pre-existing cases you have or whatever, they either have one of two choices. In my mind, that would be number one, to raise rates for everybody, to cover the cost for those different things. Or number two, say, why would I go to that state to insure? We're having a pretty hard time getting many to come to our state anyway, because we are an extremely small population. They can have more in one city than we can have in our entire state. So my concern is, with a business, how are we helping to make sure that we can sustain the businesses we have when we put the cuffs on and you can't ask this stuff for certain things? It really concerns me. We've talked about the hospitals and that, and we were able to, it appears, preserve that in the amendment. But, you know, there's more to it than that. And I think we've got to look at, where does that fit? And if somebody can answer that question, I'd sure feel comfortable with it, but I don't know. I'm still pondering with that. How does this protect the insurance we have? And how does it make sure that we're not going to have all of a sudden lack of insurance in our state, or insurance at a higher rate because they don't know who has and who doesn't have? With that, I'll sit down. Thank you.
Are you ready for the question? Senator Ellis and then Senator Steinmetz.
Thank you, Mr. Chairman. I just had a question on page 13 where it talks about childhood immunizations. As you know, the Department of Health, through rule and regulation, can develop a program to provide vaccines for children in Wyoming. And, you know, it goes on to talk about the criteria for that, those determined to be necessary for the healthy development of children and prescribed in rules. I should know this off the top of my head, of what's required for children to be enrolled in kindergarten, all that, but it's just not coming to me. So I would just like if the bringers of the bill or whoever has that information could share what the existing vaccination requirements are. And maybe a little more specifically, if there is concern that from our Department of Health that we would require a COVID vaccine. I think the argument's made that maybe there are some distinctions between the types of vaccines, those that are designed to hopefully prevent against contracting things like the flu versus those that prevent other diseases. So a little more discussion and thinking would be appreciated.
Senator Steinmetz.
Thank you, Mr. Chairman. So I'll work from the last question back. So I will find that out for you as far as vaccinations and requirements of vaccinations. But I think that that is one of the things definitely on the mind of my constituents. They believe that they have, under our Constitution, Article 1, Section 38, the right to make their own healthcare decisions, and that of those of their children. And I know that we've all heard this a million times, but it says each competent adult shall have the right to make his or her own healthcare decisions. The parent or guardian or legal representative of any other natural person shall have the right to make healthcare decisions for that person. And we know that it is our job as the legislature in Section C, the legislature may determine reasonable and necessary restrictions on the rights granted under this section. to protect the health and general welfare of the people, or to accomplish the purposes set forth in the Wyoming Constitution. The state of Wyoming shall act to preserve these rights from undue government infringement. And I think that that's why we're all here today. We want to preserve those rights from undue government infringement, and we've seen that mandate coming down from the federal government. We have many bills attempting to do the same thing, and I appreciate everyone being willing to work on those things and be here together at this time to do that. The other thing that we see in our Wyoming Constitution, and they were dealing with corporations when they set up our Constitution, was that our delegates up to that convention had some suspicion of corporations and how they would manage things or influence things and all of those things. And if you look in if you have the extended commentaries from the Oxford commentaries, they have a long paragraph on that about how they discussed that and how they tried to balance people's rights with allowing corporations to come in and do business. And I can share that with any of you that would like to see it. I don't want to take up a lot of your time, but it just says throughout the Constitutional Convention, the delegates displayed a deep-seated suspicion of corporations, particularly railroads, although some delegates had corporate connections. At the heart of this suspicion was that the belief that large, well-funded corporations would eventually corrupt the legislative process by securing the support of legislators whose first loyalty was to such corporations. This distrust of corporations was surfacing throughout the entire country as industrialization took hold. It appears to account for many of the sections of this article and throughout the entire Constitution that limit legislative authority by removing designated matters from legislative control. Convention Melvin Brown asserted that the new state would be saved the spectacle of seeing men wearing brass collars of these moneyed companies coming into the legislature and doing their bidding. I'm not suggesting that's happening here, but we know at the federal level, we see a lot of big companies that have a lot of influence this day and age. And so I think we're trying to find that place where we can protect individual freedom and liberty and defend our Constitution and not harm our businesses. But I would like to say this as well. In Title 27, and I've thought about taking a section out regarding employment and putting some of that in Title 27, we have discriminatory and unfair employment practices enumerated. And it is a discriminatory and unfair employment practice for an employer to refuse to hire or to discharge or to promote or demote or to discriminate in matters of compensation or the terms, conditions, or privileges of employment against qualified, disabled person or a person otherwise qualified because of age, sex, race, creed, color, national origin, ancestry, or pregnancy. And then if you go down, for an employer to require as a condition of employment that an employee or prospective employee use or refrain from the use of tobacco. So this is not something new that we've been doing. It's discriminatory if you base your hiring and firing decisions on the use of tobacco. So that's where we're headed, is to try to get this bill to where we can find the appropriate balance between our individual rights and between people who are vaccinated and unvaccinated, because we're seeing rifts and divisions in our communities over this issue at our school board meetings and at our city town hall meetings. And I'm trying to put us all back on an equal playing field to where we're not discriminating or dividing against one another. I admit this bill is not perfect yet. And with regard to private schools, we even talked in our committee meeting about exempting them out, but they are in the list of private accommodations that is contemplated in the bill at this time. So I hope everyone would vote to see this go to second and third reading that we could do our good work on this together as a group. And we could find a way to strike that balance that all the constituents that were in the gallery yesterday are asking for our help. And I think for me, I feel like I owe it to them to keep working on this and try to find a solution that we can move forward. So thank you, Mr. Chairman, and I'd ask you to vote aye.
We will, thank you. Senator James and then Senator Case.
Thank you, Mr. Chairman. So Article 10, Section 5 reads, "No corporation organized under the laws of Wyoming Territory or any other jurisdiction than this state shall be permitted to transact business in this state until it shall have accepted the Constitution of this state and filed such acceptance in accordance with the laws thereof." There's already something stating that businesses within this state shall follow the Constitution, which includes Article 1, Section 38. What we need to do is find something to address the problem, which is the federal government. That's what we need to do. So stop punishing the private sector and address the federal government.
Senator Case and then Senator Perkins.
Thank you very much, Mr. Chairman. I appreciate the debate that we've had on this bill. I think we've all learned a lot. Mr. Chairman, I urge us to defeat this bill right now. And it's not a thing that can be fixed. You know, and I appreciate our leadership's urging us to kind of keep this alive and try to make repairs. But the issue of the public accommodation, it's kind of a fundamental thing that we think about. Does this rise to the class that should be protected or not? I happen to have been on the other side of the famous wedding cake. Do you remember that discussion of someone that was making wedding cakes, and it turned into a huge deal? They refused to serve a customer because of their sexual orientation, if I remember that correctly. And that was a case that went all the way up. I remember lots of folks discussing that on the floor, and people concerned with politics and remembering and being very unhappy with the way the courts ruled on that, because they ruled that indeed that was a matter of public accommodation. It was protected, and indeed the person purveying the baker lost. So I find this huge irony that we value the rights of people to decide things like under the First Amendment, who you associate with, the right of assembly, free speech, fundamental rights. And we want to say, no, sorry, this time, because you want to associate or sell or purvey to people that have a certain COVID-19 status, one way or the other, or involving vaccination or some other thing, you can't do that. It doesn't bring us together to pass legislation like this. It's actually divisive. What brings us together is if we return to Wyoming's live and let live. Mr. Chairman, you do what you want to do. You have your beliefs. You exercise those beliefs until they affect me. Until we respect each other. And we respect the right of a business owner to decide. I'll tell you a little bit about my business. Fremont County was the hotbed of COVID-19 cases in early last year. It was terrible. We were very worried in my business, which is a business of public accommodation, the traveling public. We took in people that had COVID-19, and my people were terrified. We were all terrified. Nobody had to. We made accommodations. We worked out ways to seclude parts of the buildings. We worked with the public health office to make sure that some people had housing that needed housing. I can't even imagine me saying, you can't come in my business unless you are vaccinated. I'm not going to do that. But I am going to protect my employees. I'm going to make sure that they know. But this law wouldn't help. Some businesses will choose the other thing. We heard from, there was another bill, but on a similar topic, right on point, the discrimination. We heard from a business owner in Laramie who said that his employees would refuse to work if they allowed someone that wasn't vaccinated to join the employment of the company. It's their choice. Private right of assembly, First Amendment of the Constitution. Now, I don't know about all the insurance pieces of this bill. Frankly, I don't think that's been thought out enough. I'm kind of disturbed that we haven't heard from insurance carriers and the Department of Insurance. But this is, they probably haven't caught up with this yet. So, Mr. Chairman, I don't have a lot of comments about that, but I do know that I'm under the federal healthcare law that is often given a presidential name, that pre-existing conditions went out the window. So I wonder if there could be some connection within that law, and I don't know. This would actually end up being a violation of that law. I urge us to oppose this now. I don't see how it could be fixed. You can wheedle out private schools, you can wheedle out a few things, but you're still going to have this huge mass of entities out there in that deal of public accommodations. You're certainly going to have my business. Thank you, Mr. Chairman.
It's Senator Perkins, and then we'll get to the rest of you. Thank you. Whoops, Senator Perkins.
Thank you, Mr. Chairman. Mr. Chairman, I'm just responding to a question that was one of the first questions on the amendment. I did hear that some folks from the insurance department came over, had been monitoring discussion, and the answer to the question was, if, going back just a little bit of background, that was if the state mandates certain types of coverage, then what happens is the state has to pay for those for whatever you mandate. An example of that was recently, not recently, I guess it's all term of art. For my good friend from Trona County, it recently is different than it is for someone who's only been here a year or two. But a few years ago, this body's generally resisted insurance mandates, but there was a condition that came before the body called PKU, which is this, ultimately it's a condition that people can't digest food very well, and you have to have, it's very expensive. You got to have my medications, you have special diets, and it can be very, very expensive to do that. And so that came in, and ultimately I think this body passed that, if I remember right, but that's, like I say, I think that's only the fourth mandate this body's ever passed. So the question is that, and the example of that was, okay, we passed that, and at the end of the day, that's fine, but the state of Wyoming has to pay the costs of having that insurance mandate. And so that's one of the things we do when we take on. So the question was, is this a similar case? Will that result in the same situation whereas the folks the federal government who monitors insurance and oversees those types of things, will they consider this to be a coverage that has to be paid for by the state? And the answer was maybe, probably more likely than not. But there's no definition because other states have done this. It was specifically vaccination, or specifically if you were not vaccinated, that's what was happening. This one, we're threading the needle a little bit more carefully, saying it's not whether you're vaccinated, it's regardless of your vaccination. So you can't do it regardless of your vaccination state. So there's no way to know what would happen with respect to this on that. But the insurance, the employee who is in charge of kind of compliance and monitoring these things, and the way it works is the feds enforce it, but the state has to tell on ourselves. And so her job is to make sure that we tell on ourselves in accordance with law. And so what other states who did this were notified they were that they were no longer in violation, and they had to change. But I say that we put a finer point on this. But she's very concerned about that. One of the reasons she's concerned about that is because if you're an employer and you decide to do that, and the employer does it, fair enough. You get to do that. As the employer, you get to decide that. But when you place that burden on the insurer and the insurer's making that election, or the state's requiring the insurers to do that, then that's the different deal. And that's when the state of Wyoming steps up and pays that cost. And, you know, and of course that may affect so anyway, that's my report on what I found out from the insurance commissioner. And for those folks on corporations who can put a finer point on that, that's the information that I was able to obtain. Thank you.
Senator Rothfuss?
Thank you, Mr. Chairman. And I have concerns that many of which I share with those that have previously spoken, but I have a few other questions that haven't come up, and I'd be interested in understanding better the answers to them. Mr. Chairman, with regard to insurance, I'd like to hear a little bit more about why, on the justification side, why we would want a system that precluded disclosure of vaccination status or information which relates to choices. And this gets back to what is and isn't allowed under the Affordable Care Act. And if you look at smoking as an example of a personal choice that affects a health outcome that is allowed to have distinct categories under health insurance, under the Affordable Care Act of up to 150%. So an individual that is a smoker can have a policy that, all else being equal, is 150% greater than a non-smoker. It's not considered a pre-existing condition. Obviously, the Affordable Care Act precluded decisions made on pre-existing conditions because those are considered random events. The aggregation of risk in an insurance pool is supposed to account for randomization, but it's not necessarily designed to account for choices. So my question then is, if you have two groups of people that prove based on their choices to have very different health outcomes and very different healthcare costs associated with those outcomes, you've got a vaccinated population that has a very low rate of hospitalization based on COVID, and you have an unvaccinated population that has much higher hospitalization rate as well as mortality rate. They're going to experience different costs substantially associated with those. As an individual in what would be presumably the cheaper pool, I guess I would simply ask, Mr. Chairman, why do I have to pay the same rate as the other pool? That doesn't make good financial sense to me. I'm making a choice that theoretically should reduce the cost of my healthcare. I make the same choice with tobacco. I don't smoke. That leads to a lower cost. There are other choices. We all are aware of those choices that affect insurance rates based on personal choices. And so I'm just asking, why is that intrinsically an appropriate outcome that those two pools be equal? The next question, unrelated to insurance, gets to more the business sector of not being able to ask and not being able to implement policies based on vaccination status. The first of those relates to federal contractors. We know that right now, federal contracts require vaccination rates for companies that adhere and apply for federal contracts. I have certainly more than one, but one substantial company in my district that relies heavily on millions of dollars of federal contracts each year. They need to be compliant, and they need to clearly state when they're applying for those federal contracts that they're compliant with the federal contractor law. It's my understanding that if we passed this legislation, they would not be able to certify that they are compliant any longer, and therefore would be ineligible for millions of dollars of federal contracts each and every year. My expectation then, if we implemented this, is that they would move out of state. That's what I would do if I were them. They want the contracts more than they want the fresh Laramie air, unfortunately. So my question then is, am I missing something here? Because as I read this, they would be precluded from doing their business and would lose at least half of their many millions of dollars of revenue each year if this were enacted. How does this relate to federal contract law? The third sector, in a similar manner, gets to the mineral industry, where oil and gas in particular, they choose their locations and they have a lot of flexibility, not entire flexibility. They like to go where the minerals are. When faced with a circumstance, though, where they're in conflict with federal OSHA requirements and they're unable to ascertain compliance with OSHA and would therefore face penalties, has the mineral industry been consulted on whether this would affect their site location and whether they would be looking to other states where they know that they would be in compliance with both state and federal law instead of in what would appear to be conflicting compliance and potentially threatened with jail time for trying to comply with federal law that would then allow them to operate? Have we further asked oil and gas mineral sector whether they would continue to operate in violation of OSHA or whether they would see those penalties, recognizing that they're multinational corporations, not just Wyoming domiciled? Whether they would risk those federal penalties just so that they can operate in Wyoming, or whether they would cease doing business in Wyoming until they could come to a point where they were able to be compliant. I understand that MSHA, the mining safety and health, has similar standards coming forward. I further understand that there are concerns with these mining industry corporations that are multinational and have to be MSHA compliance, that they would potentially lose their permits if they weren't in compliance. Have these industries weighed in that they would like to see this legislation move forward at the risk of their permits and at the risk of their multi-million-dollar operations that bring our severance, royalties, and other revenue to the state? Is that something that we've heard from them? Have they weighed in? Mr. Chairman, a third area that I'm curious about, and honestly, I just have no idea exactly how this plays out, but we have, my understanding is over 50,000 corporations domiciled in Wyoming, many of which don't operate in Wyoming. They're not in Wyoming. They domicile here. But they operate under the laws of the state of Wyoming. So my question, and I'm curious exactly how this plays out, if this is passed, are they then obligated to operate under these statutes with regard to public accommodation and an inability to work and discuss with their employees regarding vaccination status, even if they're not operating in Wyoming? My suspicion is, since they're operating under Wyoming laws, that they would still be bound by this. And so you would have employees elsewhere all over the country that would potentially be violating Wyoming statute and sent to jail if we pass this legislation. And then my question is, if that is the case, as I understand it, what would prevent these corporations that are domiciled here, that we benefit from some revenue from, and certainly from the association, from simply re-domiciling in another state, which would basically overcome and circumvent at least 10 years of effort of trying to cultivate a sound and solid business environment in the state of Wyoming that would bring companies to domicile in the state of Wyoming and allow us the opportunity to do business with them? The fourth point, Mr. Chairman, the final, I know everybody's probably tired here, is interstate travel and accommodation. An airline being an example. We have airlines operating in many of our cities. It seems unlikely to me that they would want to change their entire corporate structure to comply with this new statute. They certainly are obligated by federal law to enforce vaccination compliance for international travel. Have we heard from airlines on how they would respond to legislation like this? Would they simply cease operation and air transport into and out of Wyoming cities? Or would they somehow continue and operate in threat of their federal licensing and registration? So for now, those are the first questions that come to my mind based on the debate that we've had. And I'll stop there, Mr. Chairman. Thank you.
Senator Salazar. And we will go to Senator Kolb.
Thank you, Mr. Chairman. So, honorable members, my name is on this bill. And as it's been stated before, it is not a perfect bill. It is not a perfect bill. I also have questions with regard to the insurance provisions. I have questions with regard to private religious schools, but it is a beginning. At least we can start. And I would ask,
Senator,
excuse me.
I believe you need to address the chair, so.
I'm
if you would
sorry.
Stand right there, that'd be perfect.
I apologize, Mr. Chairman. So, Mr. Chairman, a previous comment was made with regard to live and let live. But that is not what is happening, at least not in my district. I have absolutely heard from so many of my constituents that they don't trust the vaccination. And all they ask is the freedom to choose not to take it if they want. They're not trying to prohibit anyone who wants to take it. My point being that this bill is the best bill before us to start the process of addressing our constituents on this issue. To those who voted for a special session, such as myself, this is the bill that we should be working on. To those who did not want to adjourn, this is the instrument that I believe that we should be working on. It was stated that in our Constitution about the undue government infringement. That is what we need to address. Again, I would ask the body to vote for this, to work the bill over the coming days. Because at the end of the day, this is really the issue that we were sent here. This is the issue that I was sent by my constituents to address. And I think it would be a shame if we voted this down today, because this is the very reason why we're here. With that, thank you, Mr. Chairman.
Senator Cole, and then we will go to Senator Ellis and then Senator Biden.
Thank you, Mr. Chairman. I find it hard to stand up because I think we got to call air traffic control and find out how many black helicopters are flying above us and how much shrapnel is up in the air. I think we're a bunch of folks here that are very smart. And I look for the folks on the other side of the aisle to come up with great amendments. But I think I'm going to repeat something that I heard as a new legislator is trust the process. We're here for a reason, very good one. And it is a conflicted reason. But we have to trust the process, work the bill, and see where it comes out. Then give it your up or down vote. But I think I'm supportive of this bill. I want to see where it goes. And I hope my fellow colleagues feel the same. Thank you, Mr. Chair.
Senator Ellis and then Senator Biden.
Thank you, Mr. Chairman. I just wanted to follow up with information that I found online. My initial question was intended to be a softball for the supporters of this bill. So if it was construed in any other way, I apologize. If you look at the childhood immunization language that we find in 35-4-139, the criteria that we set as a legislature are vaccines that the Department of Health can approve are those to be determined to be necessary for the healthy development of children. That's the only criteria. But if you go look at the rules, it says a child must be immunized against the following vaccine preventable diseases: diphtheria, and I'm going to mispronounce this, I'm sure, Haemophilus influenza type B, hepatitis B, measles, mumps, pertussis, polio, pneumococcal, rotavirus, rubella, tetanus, and varicella. There are 12 on the list. So I just wanted to be kind of emphasize that the bright line I think that the Department of Health does in doing their rulemaking is vaccine preventable disease. So for those parents out there, and I'm one of them, I have 3 kids. Every year we strive to get our kids flu shots. Sometimes we do it, sometimes we don't, sometimes we forget, sometimes things fall through the cracks. So I think the point I was trying to make is I think we know that the COVID vaccines can be effective for some people, but not for everyone. And we've heard, I think, instances in our country where these vaccines can be helpful, but they don't always prevent an individual from getting COVID again or some other variant. So it's more like the flu, in my view, of what these vaccines are. And currently, Wyoming doesn't require kids get a flu vaccine every year. So I think the language that we've got on 35-4-139 to exempt COVID required vaccines is an appropriate one. But I'm just kind of curious, and I guess this is where, since we're working these bills, maybe we need to include some language that makes it a little clearer what we're trying to achieve: vaccine preventable diseases. Along those lines, I just also want to make the point that this is required in Wyoming rule. And if you wanted to, not have your kid get any one of these immunizations, you can do that if you can show a religious exemption, if your child has had that disease and has recovered from it, and you can prove that they've already had it, or get some other kind of waiver. So I would spend some time just so we all know what we're talking about and what's existing law. I'll send these rules around for your review. But I think the point that I'm just trying to make, Mr. Chairman, is that maybe we could provide some clarifying language on that front. And that even though Wyoming may not ever put COVID vaccine as a required immunization in this list, one outlying issue that I don't know how we resolve is what happens if the federal government requires it of our children. The biggest tool that they have would be to withhold federal money for Title I schools and for all the other federal programs that come in. So it might be worthy for us to at least know what that number is. And along those lines, just have a realistic expectation that even if Wyoming passes this, and I'm fine with passing this language, I do think it's important to give parents a choice. I have children that are not of vaccine age. I'm reading all the things, we're having conversations as a family of whether or not that's appropriate for our family and our kids. That's the right choice. But I just want us to have a realistic expectation that this language will not protect us if there's a federal mandate and the strings attached are withholding federal funds. Thank you, Mr. Chairman.
Senator Bateman and then Senator Hicks.
Thank you, Mr. Chairman. A couple of different things I wanted to address. First of all, a previous colleague mentioned the Supreme Court case regarding the cake baker, the Phillips case. Supreme Court actually ruled 7-2 in favor of Jack Phillips on his religious objection. So that was incorrect. Number one, if we want to go there and talk about other members' campaign rhetoric, let me ask where the civil libertarians are. Where'd they go? What about my body, my choice? Does that only apply in one instance? So those are two burning questions. Number two, the whole live and let live thing is moot because we are not living in let live. We are here because the federal government is using brute force to tell people they have to do something whether they want it or not. So as a state, it is our duty to react to the federal government, which the states created. And the federal government has certain enumerated powers. They are acting outside of those enumerated powers, and it's up to us as a state to remedy this. Now, is this vehicle the perfect vehicle? I don't know. We need to work it. We need to keep working at it. But we have civil rights laws for a reason. They exist to prevent a group of people from being treated as second-class citizens. What are we having right now with COVID? Second-class citizens. I'm hearing members who are perfectly okay with that. Think it's funny to have a vaxxed bar versus an unvaxxed bar. It's not funny to have a black-only bar and a whites-only bar. We're beyond that in this country. Thank God. But are we going back to this divisiveness with this country where we're going to treat people based on their choice of whether or not they get a vaccine, as they can't enter public buildings, they can't get a job, they can't go to a grocery store, they can't do things? We're beyond that. If we're going down that road, count me out. That's not the America I want to live in. So let's work this bill. Let's get it right. Let's fight back against the federal government. Thank you, Mr. Chairman.
Thank you, Senator Hicks and then Senator Landon and then.
Yeah, Mr. Chairman, there was a question brought up by the good minority floor leader, and I don't have an answer to all these questions. Well, let me try to answer the ones that I do have the answer for. So his concerns that one group is paying for another. We spent a significant time in committee in that, and that's if you would go back to the standing committee amendment, we struck the language out that would require that an employer could not increase their premiums for that very reason. We understand that component. But if you read the bill and you read the bill carefully, it only says that you can do that for the status, not the experience and the cost of the employer. So what the bill says is I'm either vaccinated or I'm unvaccinated. You can't raise rates. You can't cancel my policy because of my status. It's perfectly permissible under this legislation for an insurer to come in and raise their rates on those premiums based on their experience. That's allowable. So we tried to address that in the standing committee. I think we accomplished that. So the other questions were posed, I don't have an answer for. But I know they deserve an answer. And the way you get those answers, Mr. Chairman, is you follow the process. So this is the way it works. Somebody poses a question out here on the floor. I may not have the answer, but I darn sure know the people that do have the answer, and we will provide those answers. It's called a second reading, Mr. Chairman. So if you really want an answer to the question, and your intent is not for some other purpose, then allow the process the opportunity to answer your questions. Let's vote this on and get the answers to those questions from the people that have asked. That's the process, Mr. Chairman.
Senator Landon and then Senator Scott. Senator Landon.
Chairman, I'm waiting for a green light, but maybe I'm already on.
Oh, you know what? I pressed Senator Dockstader.
Thank you very
You
much.
are on.
Thank you, Mr. Chairman. Really, no, I appreciate the previous 4 or 5 speakers and talking about process and keeping things alive, and we get that. I mean, I totally get that, and I know that's the reason we're here. That's what we're talking about, and often Vice President's right. We get those answers in the second reading and whatever, and I look forward to that. I think many of us are willing to work this, but I think it's important to remember also that there are some very important questions being asked today. I took you to page 7 because, like the good senator from the eastern part of the state, I've got a lot of constituents. They weren't in the balcony yesterday. A couple of them were. Most of them are back home running businesses. And I've got businesses back home who are mortified with some provisions in this bill. I wonder, for example, and I was going to ask our standing committee, was there any conversation about taking the punitive damages out of this thing? We can make this illegal to do this. Do we need imprisonment and fines for businesses? Just curious. And I'm still curious about the fact that, do we need the language in there that says we're going to allow for all kinds of civil actions against our businesses out there who have been through the last 2 years. And now we're going to throw this out there and say, you know what? Everybody that walks in your door, if you don't walk on eggshells with them and avoid all of this, they're going to bring civil action against you. And we might have all sorts of those things flying around. And that's good news for our attorneys. I don't know that that's good news for our state. So my point is, folks, that's what we got to do here. It's not just keep something alive. We've got to find the answers to this. I got a great email this week from a hospital right next to where I live. And because of their relationship with the federal government, we would stand to lose the ability to fund 2/3 of our adolescent youth in that hospital who are there for reasons that we really need them to be there. That means that 2/3 of them would have to leave that facility if we're not careful. So I just throw that out as part of this discussion as well. So we really do have to find the answers. Guys, it's not just keep it alive in this language. We don't know for sure. We heard this morning that this might cost our state a lot of money. I know how hard my friends on the Appropriations Committee work to, for goodness sake, we've been trimming jobs and everything else, and now we've got this thing hanging out here. We don't even know what this might cost. I hope we can find the answers, senators. Thank you.
Senator Scott.
Mr. Chairman, trying to answer, one of the points that was raised by the distinguished minority floor leader with regard to the state of incorporation. What is going to govern is not the state of incorporation, but where the operations are, given the nature of what we're talking about here. So, for example, in the state of incorporation would determine things like, nature of your board, what kind of articles you have to file, what's the standards for behavior of directors, that kind of thing. And that does make a difference. That helps us get business here. The fees we charge for being a state of incorporation are very important. That's probably what's the major thing, bringing business in there. But with regard to this bill, I think it's where the operations are that counts. So to take the example of the firm in your community that is largely dependent on federal contracts and might feel it has to leave and take its operations to a different state and its employment to a different state because of this legislation. That would be a very valid concern. That would be a real negative, is a real negative for this bill. But they could keep their incorporation here in Wyoming without having that follow them to the next state. And if they went, for instance, to Fort Collins, just over the border to our south, they'd be subject to the laws of Colorado with regard to their operations, with regard to the things that we're talking about here. Their incorporation in Wyoming wouldn't make any difference. So I hope that reduces the number, and I'm sure I'll be corrected by the real attorneys if I'm wrong, but I don't think I am. I think that answers one of the issues that's been raised. But the other issues that were raised there, I think are very valid.
Senator Dockstader and then Senator Perkins.
We'll come back. I want to make sure the chair has a chance to come back, but folks, it's rare you've had this kind of time to debate a matter. Think about it. We've been all morning on this. Haven't had that kind of opportunity over the years. And that's just it. You're still going to have a lot of time and a lot of opportunity to work this bill and get it where it needs to be and make sure that we do what we were asked to do to come down here and address the mandates and address COVID. And this bill is one of those that does it. And we will take the time. I urge you to pass it, move it forward, and make the corrections that are necessary. With that, we'll let the good chairman who has worked this bill say a few more words. Thank you, Mr. Chairman.
Senator Perkins.
Thank you, Mr. Chairman. Again, just to rise and answer some questions that were asked, particularly back to OSHA and those requirements, because most of you have OSHA covered businesses in your jurisdictions, construction, industry, manufacturing, oil and gas. And so we're concerned about that. I mean, what happens? So just a little bit of background, and because I knew this bill was assigned, I've been working hard since it was assigned to me yesterday to try and come up with some of these answers, because these are all, some of these questions I didn't think of, and some of them I have. I've been trying to find answers. So I did take the opportunity to call the Department of Workforce Services yesterday and talked with the director and the reason I called them is because one of their responsibilities is to oversee OSHA in the state of Wyoming. So Wyoming and I believe 21 other states, I think there's 22 states in total, have what are called state approved OSHA plans. And so what it is OSHA is set by federal regulation, federal law. And then ultimately, if you stand up an organization to work and enforce that, then you can have state primacy essentially. And so you have a state approved plan, and your state approved plan only remains approved so long as you are in conformity with the overlying and the overlying construction of the federal statute. The reason that we haven't heard about OSHA yet is because there is no official, the executive order everybody's anticipating has not yet come down. So there's not a lot to respond to in that regard. However, there was an emergency temporary order that has been issued to OSHA. And there are 4 states who did not adopt that plan. It wasn't because I don't know about all of them if it was special legislation, but the state to our southwest, of which we really appreciate Everson because it took a nice notch out of that state. When the executive temporary order came down, the governor in his executive capacity basically said, no, we're not going to take that. And that order is is a temporary mask mandate till the official order, vaccinations, covers vaccinations. Does provide some exceptions, but not a lot of detail on the exceptions is my understanding. To do that. And so that executive temporary order came down, and the governor in his executive capacity said, we are not going to accept or adopt the OSHA emergency temporary order. The effect of that has been, and 4 other states are in a similar position, although I don't know if it's because of special sessions or if it's because of executive action, have also. So we have our friends in Utah, Tennessee, South Carolina, and Tennessee are all pretty much in the same boat. Wait, and what? And, oh, excuse me, you're right, Arizona, I misspoke, Arizona. And they find themselves in the same position that now what the effect have been is they have received notice that they're in violation and no longer have a state approved plan. What's the effect of that? Well, the effect of that is that enforcement now goes back to the federal government, and the federal government is now issuing citations and enforcing OSHA violations in that state. So what is that? What did Wyoming do with that? Wyoming did something I thought was very smart. Wyoming adopted the order in part and did not adopt the order in part. They adopted the requirement that about vaccines, but on the exceptions, they said that we have other provisions in place that are sufficient to that provide the same safeguards as, but that the exemptions in the statute do. So the effect of that is that they did receive a letter from the federal government, from federal OSHA, saying you are no longer in compliance, but we want to talk to you more about your alternative measures that you think are just as important. And as such, the state heads have not taken in. They've noticed we're not in compliance, but we're now in negotiation with them to see if the exceptions and how we're trying to deal with that is going to be acceptable. So what that tells you is 2 things, I believe, is one is to simply, if you pass this mandate and you make it an employment and you do all that, then you put yourself in the same position. I think that there's a high likelihood, and I asked the director essentially if we pass this plan. Actually, she was a law school classmate of mine at the University of Wyoming, but I asked her if we pass this plan, if we pass this without some kind of qualifying language in it, do you believe that will make us make our stand not our state plan no longer an approved state plan? She said, yes, I'm very afraid that it would. So in doing that, I think there's the 2 lessons to be learned are, one, that I think there's ways that you can do this. You have to be very careful, but you have to thread, if you're going to do this, you have to thread the needle carefully, because I agree wholeheartedly with my good friend from Rock Springs. Is the point of this is the issue is between us and the federal government. It's about overreach. It's about state sovereignty. Those are the underlying issues. How do we fight back? Well, do we fight that back by we're going to send troops off to fight this battle? Are they going to be the employers of our state that we sacrifice to the altar of fines and litigation that bankrupts them? Are we going to do that? Is that how we're going to fight that? Are we going to expend those soldiers, charge the hill, go get them, you guys, we're right behind you? Or are we going to try and be intelligent about this so that we do this and don't put that burden on the state, on the employees of the state of Wyoming? There was a great email that a good friend on the other side received from an employer that said, you need to make sure that you don't infringe on my rights as an employer to do whatever I want and protect all the private rights of employees. Well, guess what? Those 2 things are in tension. They're fighting each other. This bill brings that home. So it's up to us, if we move this bill forward, to continue to work on this and find a way to thread that needle and try and find the right balance between those tensions, because both the employees and the employers are right, and they both deserve all of our consideration and all the protection we can give them. And they certainly don't need to be sacrificed charging up the hill in our battle with the federal government. Thank you, Mr. Chairman.
Senator Kinski.
Thank you, Mr. Chairman. I'd like to follow up, again, agreeing with our colleague from Rock Springs. He's not here to hear so much agreement with him. It's too bad, but we don't want to punish the victim. I oppose mandates. I oppose what this administration's doing. But we do not want to punish the victims, which is Wyoming businesses. So I'd like to read to you a letter that I received from, I made reference previously to a business in our town that has a lot of defense work. Dear legislators, I write this email to inform you of what we are facing regarding the president's executive order on vaccination mandates. It's important to me that you are all aware of the situation our business is currently experiencing as you head to Cheyenne. First off, I personally believe in getting COVID vaccinations. I'm proud our business is 60%, 70% vaccinated. That said, I believe stronger in a person's choice, which is why we have never considered mandating vaccinations as a condition of employment. Although the executive order surrounding the vaccine mandate has some ambiguous qualities, it does appear clear that all of our employees have to become vaccinated due to our status as a federal contractor. 2/3 of our business comes from the Department of Defense. This company does some very innovative things. As of last week, we received our first notice of a contract, including language requiring compliance to the executive order. I will wait this out for as long as possible to gain more clarity. But after November 14th, if and when we start getting DoD contracts that include that mandate language, this will be a simple business decision. I hope we don't follow the Texas model. Something like penalizing a Wyoming business or person for following a federal law in order to retain most of its revenue and workforce would be a detriment to us and many other businesses. That's my greatest reservation about this bill and others. These folks have no choice. You could tell them, well, you can sue in court, you could seek an injunction. Meanwhile, they're bankrupt. They don't have that option. And so amongst other concerns I have about Senate File 1003, the primary one is we have to exempt people who are already being victimized by this order and not punish them yet further again. Thank you, Mr. Chairman.
Senator Steinmetz, I thought we might be done.
Thank you, Mr. Chairman. Just to bring it home, I appreciate all the good discussion, appreciate all the questions. We'll continue to work on this if you give us the chance. So I'd call for the question.
Senator Boner.
Okay, sorry about that, Mr. Chairman. I had my hand up over here in the corner, but just briefly.
I apologize to you because I keep missing you, but.
Oh, that's okay. It's partially due to my decision. So I appreciate that, Mr. Chairman. Just real quick, I appreciate the discussion from some of my colleagues about why we're here, why we're in this special session. And just to be crystal clear, the voices I heard from my constituents were around two areas. First of all, everybody's concerned about the federal overreach and pushing back and doing what we can to make sure that federal government doesn't require vaccinations through OSHA or other things. The other one is people are concerned about losing their jobs. Maybe they work for a large corporation that is somewhat out of step with the realities here on the ground in Wyoming. And so I do trust in the process, which is precisely why I feel comfortable not supporting this particular piece of legislation, which goes far beyond protecting people's jobs and protecting people and our citizens from federal overreach. There are other better vehicles for that. I'm confident we'll see that in those vehicles in this chamber. And I just have to say, I have not heard a single solitary complaint from any of my constituents about being denied public accommodations. That'd be a very poor business decision in rural eastern Wyoming. I can tell you that any business that mandates any sort of vaccine is probably going to go out of business very quickly. And so I don't see this very broad reaching bill addressing the issues that we are all here to do and to deal with. And it has a lot of unintended consequences, I think, and the number of times I've heard, we'll get back to you on second reading, is a cause for concern as well. So just pointing out that as far as I understand it, and the reason why I'm in support of the special session is primarily to protect people's jobs. from both overreaching government and overreaching corporations. And this bill deals with so many other things than just that. So just want to make that clear. Very supportive of the special session, but still struggling with this piece of legislation.
Are you ready for the question? All those in favor of Senator Perkins' motion that when the committee of the whole rises to report that it do so with a favorable. All those in favor, no, thank you. All those in favor of Senator Perkins' motion that when the committee of the whole rises to report that it do so with a favorable recommendation of Senate File 1003, say aye. Aye. Opposed, no. No. Senate File 100, division being called. All those in favor, please rise. All 18 yeses. All those opposed, please rise. Noes 10. Senate File 1003 has passed committee of the whole. The next bill for our consideration is not available. Mr. Majority Floor Leader. You have heard the motion. All those in favor, please say aye. Opposed, no. Motion passes. Mr. President.
Clerk, read committee of the whole report.
Mr. President, your committee of the whole, having had under consideration bills on general file, begs leave to report as follows. Senate File 1019, do pass. Senate File 1003, do pass amended. Senator Wasserberger, Chairman.
Senator Wasserberger.
Mr. President, I move the adoption of the committee of the whole report.
You've heard the motion. All those in favor say aye. Those opposed, nay. Motion carried and the report has been adopted. Mr. Floor Leader. What's your direction?
Mr. Chairman, or Mr. President, I move that we stand adjourned until 8:30 tomorrow.
8:30 tomorrow. Okay, any announcements? Any announcements? Oh, there you are, Senator Landon.
Mr. President, thank you. And I hope this is not out of order, but I wondered if there was any sense yet as to how you think the next few days will play out. We're dealing over the noon hour and other times with what to do with several meetings that we have.
Correct. Thank you.
Basically lost the
Mr.
opportunity
Floor
to
Leader
hold.
is
So,
just
thank you.
ready to answer that for you. Mr. Floor Leader, you've been visiting with a lot of people. Go ahead. Mr. Majority Floor Leader. Yeah, you've been called upon to give us a summary of how the next few days will work.
Wow, that's kind of tough. That's what I was sitting here visiting about. It's a little bit loose right now. It depends what comes from the House. We're trying to stay on schedule as much as we can. But most likely the scenario we're under after visiting with the House is we will go through Friday and be back in on Monday and Tuesday next week to finish it up. And it depends a little bit on the end for the veto, if there ends up being a veto override, but almost certainly we're going to be in Monday, Tuesday, possibly Wednesday next week.
Senator Landon, do you want to follow up on that?
Thank you, Mr. President. I really appreciate that. We've got several committees that are being bumped, and so that's helpful to those of us trying to find a place to put them. Transportation, Military Affairs, for example. I think our Minerals Committee, we've got several standing committee appointments next week that'll have to be moved. So stay tuned and we'll try to let you know as chairman. I'm sure we'll let you know the dates.
Thank you, Mr. Chairman, and that was part of our discussion. And as we have a little further discussion with the other side of the building, we'll come back with our two chairs there, Minerals and Transportation. Any further announcements? You've heard the motion. Stand adjourned until 8:30 tomorrow morning. All those in favor say aye. Those opposed, nay. Motion is passed.